Breaking news, Nigerians. Nnamdi Kanu, the leader of the indigenous people of Biafra, has petitioned the Chief Justice of Nigeria and the chairman of the National Judicial Council, CJN, Kudirat Kekere against Justice Binta, Nyako of the Federal High Court, Abuja. Now, Justice Binta Nyako is being accused of judicial misconduct in the handling of Nnamdi Kanu's case, where Nnamdi Kanu, who filed the petition through his younger brother, Prince Emmanuel Kanu, recalled that Justice Nyako had earlier granted him bail and then later revoked the bail and issued a bench warrant against him, which led to his abduction in Kenya on June 19, 2021, and the extraordinary rendition to Nigeria to face his ongoing trial. He recounted that on June 29, 2021, he was secretly produced before Justice Binta Nyako in violation of the Section 36(3) and the Section 36(4)(a) of the 1999 Constitution of the Federal Republic of Nigeria. Nnamdi Kanu mentioned that without the presence of his counsel of record, Justice Binta Nyako conducted a hearing that led to his remand in the custody of the Department of State Service, DSS, and responsible for his extraordinary rendition. And now, Nnamdi Kanu have noted that this lady must go. Yes, my country people. Nnamdi Kanu, we can recall that on the hearing on April 17, 2024, his counsel filed an application before Justice Binta Nyako to restore his revoked bail in line with the judgment and the pronouncement of the Supreme Court on December 15, 2023, where the Supreme Court in its judgment had held that Nnamdi Kanu, who was on bail and therefore in the custody of the law with his home, was illegally invaded by heavily armed military officials of the appellant, causing him to flee from his home and the country to secure his life. And in the face of such an attack, it was responsible for him to flee to secure his life and his physical well-being. But then, that is what any normal and reasonable human being would do, given that circumstances, to preserve his life and his physical well-being. And it is glaring that the consequences of that attack were intended or foreseeable, and this is not arguable. The appellant officials know that their invasion of the respondent's home caused him to run away to secure his life and his physical well-being. Yet, during proceedings in the pending criminal case against Nnamdi Kanu, they applied that his bail should be revoked and that a warrant for his arrest should be issued, and then his sureties should forfeit their respective bail bond, and that his trial in his absence be ordered because he had jumped bail and is not in court to stand his trial. But they know that their illegal actions made it impossible for Nnamdi Kanu to be in court for his trial. And in a situation such as this one, where the prosecution has taken extrajudicial actions against the defendant in a pending criminal case brought by it, and made impossible for the defendant who is on bail to be in court for his or her trial. And it is wrong, very, very wrong, to treat such a defendant as having jumped bail in the sense that he is running from prosecution or he is running to avoid prosecution in the pending criminal case, in respect of which he was granted bail. And the respondent, Nnamdi Kanu, did not intentionally and knowingly fail to appear in court. So it was quite wrong and it was malicious for the federal government and their agencies to say that Nnamdi Kanu fled from his home country to secure his life, and that therefore caused his unavoidable absence from court to inform and thereby deceive the trial court that Nnamdi Kanu had jumped bail. And on the basis of that particular deception, the appellant applied to the trial court for an order revoking the respondent's bail, revoking Nnamdi Kanu's bail, forfeiting the amount, securing the bail bond of his sureties, and an order issuing a bench warrant for his arrest. And it is glaring for the records of the proceedings in the trial court that it granted the said orders prayed for by the federal government with knowledge of the fact that Nnamdi Kanu's absence from the court was caused by the invasion of his home by armed army officials from the federal government. And therefore, the trial court knew that the said extrajudicial and illegal actions of the federal government made it quite impossible for Nnamdi Kanu to be in court for his trial, and his absence should not be tagged as intentional or deliberate absence. They should not tag it as such, that he was trying to run away from prosecution or he was running to avoid being prosecuted. And in the light of the foregoing, the trial court had acted unfairly and without rational and legal justifiable basis for its decision of revoking Nnamdi Kanu's bail, forfeiting the amount, securing the bail bond of his sureties, and an order issuing a bench warrant for his arrest. But then the Nigerian government, they will put their hands on their ears and they will do like they are not hearing what the court is saying. They will turn deaf and dumb to whatever to the judgment of the court. And Nnamdi Kanu also recalled how he applied for transfer from the DSS custody because of the restrictions being placed on him by the DSS officials with regard to his constitutional right of access to his counsel. You recall that on several occasions, Nnamdi Kanu will be crying that the DSS have been eavesdropping on some of his conversations with his lawyers, with his counsel, and that has really affected him. It really posed a major setback for his legal trial proceedings and the seizure of some of his most important legal documents. And all these things they've been doing, sometimes they deny him the right to see his lawyers, sometimes they deny him the right to see his families, or his family members, they deny them the right to have access to Nnamdi Kanu. And on several occasions, they've also denied Nnamdi Kanu access to his lawyers. So they have called out Justice Binta Nyako that Justice Kekere should come and look over this issue, because Justice Binta Nyako has really done a lot of misdeeds, that needs disciplinary action. Guys, what are your thoughts on this? I'm dropping here. Kindly share your thoughts concerning this in the comments.